The Board of Metropolitan District Commission come to order for the special meeting of Monday, January 23rd, 2023 at 1 p.m. Would the clerk please read the roll?
DeBella.
Here.
Adel. Here. Anderson.
Here.
Abedisian. Pisano.
Here.
Buell. Bush. Here. Curry. Here. Pasai.
Here.
Drake. Gale. Gardeau. Gentile.
Here.
Healy. Hoffman. Hoheb. Holloway. LaChance. Lester. Lewis.
Here.
Magnan. Maniscalco. Mandyke. Payne.
Here.
Patel. Potowski. Here. Salemi. Stuber. Taylor. Here. Torres. Here. Wolf. Carrier. We don't have to. Yep, we can move forward without the quorum.
Yeah, we're one short. We can still move forward. It's an informational meeting, so we can move forward. Before we do and ask for public comments, I just wanted to, those people that haven't seen the obituary, one of our former commissioners has passed away, Dan Camilleri, who was a member of the district board for 18 years, served with several of us. It was a legend in his own, not in his own mind, definitely in his own time. Yeah. And the issue is he's served in public service, not only in the MDC, on the town of Wethersfield. He was a state senator for 2 terms, and I believe it must have been the early 70s. And he was also pharmaceutical, I guess a commissioner on the pharmaceutical board of the state of Connecticut, and well known. Danny was almost 101. He was, I think in March, he was going to be 101 years old. And a wonderful person, a person that gave an awful lot back to the public relative to the 70 or 80 years that he was involved in that process. He was also, I believe, he served on the Harvard City Council. He was the youngest person to ever serve on the council. And it was a close personal friend of mine. And his son was my chief of staff when I was in the state senate, Anthony, Tony. So, just let you know, today is the calling hours are from 3 to 7 at the DeSoto Funeral Chapel in Wethersfield. And tomorrow at Corpus Christi's Church at 11 o'clock, there'll be a funeral mass for Dan. Just a public process. Public comments relative to agenda items.
Judy Allen, West Hartford. Mostly, I was reading through the new ethics bylaws. Actually, I'm not sure I got the newest version online, but I'm hoping that it says policy and interest is shared with a substantial segment of the population of the municipality. I'm just wondering what that looks like, what that means, because it's sort of vague and curious to me. Thank you.
Okay. For the purpose of presentation, I'm going to ask one of our counsel, Mr. Bonafanti, to introduce our program today.
Thank you, Mr. Chairman. Commissioners, today we have our guest speaker and presenter, Attorney Peter Lewandowski, who's the Executive Director of the Office of State Ethics. As you're aware, as we worked through passing through the board committees and the district board, the policy acknowledgement and disclosure of conflicts of interest form, which is due to be remitted by the end of the month, as well as the bylaw change, we committed to having some training relating to the identification of what is a conflict of interest, identifying that, and also to be able to put that into context with respect to these new forms. So Mr. Lewandowski graciously agreed to come and provide this training to us today. He's at the Office of State Ethics, which is, he'll tell you and provide the appropriate disclaimers about their role in administering state statutes with state agencies. But we have him here today. I also know that we have made arrangements to record the presentation for those commissioners and members who are not able to attend in person today, so that it will be available to them either for reference or for replay. So with no further ado, Peter, thank you again for being here today, and the floor is yours.
Thank you, Steve. Again, good afternoon, everyone. Just for the record, my name is Peter Lewandowski. I'm the Executive Director of the Office of State Ethics. And as Steve already noted, I will start first with a disclaimer. We'll obviously talk about conflicts of interest and related disclosures that this body is adopting and will file. We, as the Office of State Ethics, have jurisdiction over state government, and we do not exercise jurisdiction over municipalities or regional or district boards. Nonetheless, we do provide presentations such as this one on best practices in governmental ethics. I've done many seminars to municipalities, for example, on a wide range of topics. For your purposes, obviously, the focus will be on conflicts of interest. And again, at the end, I'll entertain any questions you may have. I have a short PowerPoint presentation that will first focus on just the general concept of conflicts and policy behind it, and general idea of disclosures, and then we can jump into, again, some of the disclosures that you will be required to submit. So let's start. Again, when we talk about conflicts of interest, really this is one of the most fundamental provisions, one of the most fundamental provisions in governmental ethics. Really, if there was an equivalent of the Ten Commandments in governmental ethics, conflicts of interest would be at the very top. So it is a very important provision. You will find it in any governmental ethics code, whether it's on the federal level, any state level, municipal, and you obviously have adopted your bylaws that require disclosure of interest. Generally, when we talk about approaches to ethics laws, there are varied approaches to ethics, governmental ethics laws. The most common one, obviously, are prohibitions and disclosures, or both. So if you have a conflict of interest, you disclose it. You may be required to abstain from official action. And sometimes, depending on the nature of the conflict, if it's a direct, substantial conflict, and we'll talk about direct conflict shortly, you will be required to abstain from official action. Then, of course, if we're talking about potential conflicts, there may be disclosure requirements and so on. So, when we talk about conflicts of interest, what's the general policy behind that provision? Well, clearly the one on the very top, to prevent corruption, to protect government interests of this body, of this entity, to attract good public servants, and to provide transparency. Transparency obviously is critical, and an element of that are actually the disclosure forms of disclosing conflicts potential for conflicts and so on. And why do we disclose? There are various disclosure forms that you'll encounter, whether in not only in this body, but also if you are serving on other boards, state boards or municipal boards. Generally, the basic thrust behind disclosures is to maximize public confidence in governmental decision-making, and also to provide kind of an individual checklist for you. You may be involved in various activities. Your family may be involved in various activities, and we're talking about immediate family members. You may be participant in various business activities. So it's good to have that checklist in place. So when you are to take official action here, you know, okay, well, wait a minute, there's something on the agenda that poses a conflict for me, and you obviously take appropriate steps to not to participate, but the recusal, or making a statement on the record to inform the public that you have a potential conflict. Conflicts of interest. So how do we spot conflicts, generally speaking? There are a series of questions that you really have to ask yourself when dealing with a conflict. First and foremost, will you derive financial benefit from your official action? You yourself, will there be a benefit that will accrue to you? Will your immediate family members benefit from your action? Will any affiliated businesses benefit from your action? And finally, and this is a very important question at the end, is the benefit distinct from other similarly situated persons? Okay. Are you being treated in some distinct fashion than others in the same group, industry, occupation, profession? Okay. So that's a very important question. So if you answer yes to any of these questions, well, you have a conflict. And so now it depends, what are we dealing with? Are we dealing with direct conflicts, potential conflicts, and is there an appearance of a conflict? Let's start with direct conflicts. Those are usually easy to spot. You have essentially a reason to believe or expect that you, your immediate family members, any associated businesses or affiliated businesses will obtain direct monetary gain or suffer direct monetary loss by reason of your official activity in a way that is distinctly different from its effect on other persons in the same occupation or group. Just to unpack this, in terms of family members, you in your forms you define what's a family member, and again, we're not talking about distant cousins. We're talking about immediate family members. So your spouse, your siblings, children, natural or adopted, grandchildren, spouses of siblings, children, or grandchildren. So that's how you define a family member. And again, some other codes may also include parents and your parents. So it is a limited universe of folks. We're not talking about extended family members, immediate family members. What about associated businesses? Again, we're talking about businesses with which you or your immediate family member has some kind of status or interaction with, whether in capacity of the director, trustee, officer, or owner of, or shareholder, owner of a certain percentage of stock. In your case, I think I noted there's a reference to, when it comes to business transactions, owner of greater than 35% of the entity. And also when we're talking about investment entities, 10% as well, ownership of stock, either having voting power or value of the corporation or the entity. So that's essentially, again, the universe of an associated business or affiliated business is defined in your forms, and be aware of what that universe looks like. And finally, ultimately, when dealing with direct conflict is the importance of, are you being treated in any distinct fashion? And we're talking about large groups here, not just small segment of, let's say, an industry or occupation or profession. So for example, let's say there is a matter pending before you, and you have an entity that's applying for something, and you determine that, well, let's say your spouse is an officer or a part owner of that entity, well, you have a conflict. Now, is that entity being treated in any distinct fashion from other similarly situated entities? Is this applicable to all groups, all businesses within that industry? If, however, the distinction is, focused on that particular associated business, then yeah, you do have a conflict, and in direct conflict, you are required to recuse yourself and to abstain from official action. Just to illustrate what direct conflict would look like, for example, and these are examples from that we've encountered at the Office of State Ethics, and they're similar in other contexts. For example, an official failed to recuse himself from taking official action on his own workers' compensation claim, which resulted in his financial advantage. Clearly, there was a direct interest, financial interest in that type of a scenario. An official awarded a graduate fellowship to official spouse, directed others to hire the official spouse as a graduate assistant, providing financial benefits to the spouse in excess of $50,000. Essentially, when we're talking about direct conflict, there are no intervening conditions. The benefit is immediate. You take official action, and the benefit accrues to you or your associated business or your family member. Now, what about potential conflict? A little bit more nuanced, but essentially when we're talking about potential conflict, and this is again in general terms, you encounter potential conflicts when you're required to take official action that would benefit, that would affect a financial interest of either you, your spouse, and again, your family member, as we listed earlier, and also any associated businesses or affiliated businesses. And that there's no potential conflict if any resultant gain or loss is equal to a substantial segment of the public. So, for example, all homeowners, all taxpayers. Again, we're thinking of large groups when we're talking about the distinct treatment, not just a small subset or subgroup of individuals, affected individuals. And unless there's some kind of a de minimis standard imposed. In this case, in our case, for example, on the state level, we have a $100 de minimis benefit that is not considered a conflict if it's under $100. Now, what's the test for potential conflict? As I said earlier, with direct conflict, there are no intervening conditions. The direct conflict is immediate. Under potential conflicts, however, you have this reasonable expectation that you will derive some financial, that there will be some financial impact that's based on your actions. Okay, so there's no requirement that that the financial impact be direct. There has to be that reasonable expectation. In other words, it has to be considered likely, as opposed to merely conceivable or possible. Many things in the world are possible, but not considered likely. So there has to be that likelihood, that reasonable expectation that you will derive financial benefit for a potential conflict to exist. And what to do when faced with potential conflicts? Well, it depends on various codes and bylaws. if you are a member of a deliberative body such as this, you may be required to abstain from official action and disclose, and/or, you just simply disclose. And on the state level, for example, if you are a member, and some of you, if you serve on state boards, you may be aware of this. If you're on the deliberative body, a member of a deliberative body, you have to disclose the potential conflict. However, you may either abstain or state on the record that despite the conflict, you are acting in public interest. For employees, it may be different. Employees may be treated differently in terms of potential, how they, when they encounter potential conflict. They may have to not only abstain and disclose, but also there may be a mechanism to inform their immediate supervisor, because supervisors may be involved in redirecting a conflicted matter to another employee. So that's important. Supervisors should be involved in that regard if we're dealing with employees. This way, the operations of the entity are not disrupted, and the matter would be then transferred to an employee of equal or higher rank if we're dealing with potential conflicts. Examples of potential conflicts. Here, these are just illustrations. Employee failed to inform his superiors when he was faced with a conflict of interest involving the hiring of his son by a contractor over which he had administrative oversight. And in this scenario, oversight in terms of hiring and payroll approval. Sometimes that could be the case if, let's say, a contractor submits invoices, and let's say you have an individual who's responsible for making sure that those invoices are accurate. Clearly, some administrative oversight. So, a potential conflict in terms of hiring a child or immediate family member. Another example, an official created an $80,000 temporary worker position and a proposed grant for an entity that the official intended to obtain upon official's retirement from public service. Again, kind of creating your own position as you are departing public service. That's also prohibited, although in that case, that temporary worker position had to be approved by others. The conflict wasn't direct. There was other conditions that had to be met. But nonetheless, it created a potential conflict for that individual. All right, appearances of a conflict. What we're talking about here are generally the issues of optics. How do things look when we are taking official action? You may determine, as you are going through these checklists, through these disclosure forms, well, you don't have a direct conflict, you don't have a potential conflict, but there may be an appearance issue. And so how do we define or how do we capture appearances? And by the way, the Office of State Ethics, when we deal with state agencies, the Code of Ethics on the state level is silent as to appearances. We do not have jurisdiction over appearances, but some other governmental entities, municipal or what have you, may apply the so-called reasonable person standard when dealing with appearance. So for example, if you're acting in a manner that would cause a reasonable person to think that you can be improperly influenced. When dealing with appearances, consider whether your relationships and affiliations could prevent you from acting fairly and objectively. And if the answer is yes, generally the best way to dispel an appearance concern is disclosure, a statement that despite the appearance, you can still act fairly and objectively. So whenever you find an appearance concern, again, putting aside direct and potential conflict, but strictly appearances, disclosure is probably the best remedy. Excuse me. And also, when dealing with appearances, you know, it all depends on what we're talking about. The facts will be very much critical. We've issued, I mentioned earlier that, for example, you know, what's an affiliated business or what's an associated business? And there may be certain thresholds for you to meet to have a business considered an associated business. I said 10% or 35%. So let's assume for a second you're a shareholder of a business and you own, let's say, less than 5% of the stock of that business. Well, technically, under your rules, the business is not considered an associated business. You didn't cross the threshold of ownership, okay? But it's still for folks out there, for a reasonable person, they may think, well, you own less than 5%, you didn't cross the threshold for that business to be considered an affiliated business. Can you act fairly and objectively? Well, clearly, there may be an appearance issue, but at that point, if you own less than 5%, the business is not considered an associated business. Just simply state so, and that you can act objectively, and that there is, again, very little likelihood of, you know, you're not being influenced, let's say, by the business or some other, I don't know, nefarious pressures or what have you, not promising anyone anything. So again, full disclosure, as you will see, facts are critical in when dealing with appearances. And then the other option of dealing with appearances, well, if you have an appearance issue, you can always abstain, even though you don't have legal duty or legal obligation to abstain if it's strictly an appearance concern. All right, just a few words about your disclosure and disclosure forms. I'm going to first start or focus on the Code of Ethics Policy Acknowledgement and Disclosure of Potential Conflicts of Interest. And in terms of, again, these disclosure forms, those are standard forms that you see in kind of governmental ethics context. Family members defined, and I've mentioned the definition already. The business relationship is also defined as to what type of transactions or relationships would pose an issue for you if you were to ever take official action on a matter pending before this body. You know, in terms of listing, I think it's important to revisit. I'm assuming members will be filing these on the annual basis, or
upgrade.
Or update when necessary. So again, I think that's a very reasonable, and I would commend you for doing this. I think it captures you know, various relationships, both business and family relationships. And just keep in mind the definitions that are utilized in the form, and they're noted in the footnotes, whether it's a business or family relationship we're dealing with. Also, there's obviously item number 4, continued appointment, eligibility, and additional potential conflicts of interest, dealing with issues of in terms of, you know, what your appointment requires to be a resident or elector of a specific municipality. If there are issues also involving immediate family members and their activity that would pose a potential conflict for you, and then you have to attest and certify this form. As I said, this is very much a standard form that covers basic, you know, requirements for potential conflicts. You also have two other forms, one dealing with procurement, a source selection participation agreement, also based on financial interests or business affiliation that you may have with potential folks who potentially may be engaging in procurement activities with this body, and where you have to disclose those type of conflicts, if any arise. You have, and it's pretty broad here. You have, for example, you note, item number 6, to the best of your knowledge, except as noted below, none of the following are reasonably likely responded or proposed subcontractor to this particular procurement. And the folks listed here, any person or company with whom you may be, you have or seeking a business, contractual, or other family financial relationship, a close relative, a person or company with whom you may have been affiliated within the last year, and finally an organization in which you are an active participant. And then, of course, there are rules of conduct during this procurement process. Again, it captures potential conflicts as well as any other issues that may arise in the procurement process. And I think, again, it's a good checklist for those type of scenarios involving procurement. Finally, request for information. This is kind of a mirror agreement similar to procurement source selection agreement. Also fairly comprehensive, and it also communicates and provides for defines financial interest, affiliation, and those situations where you have to be on the lookout for it. So I would also recommend that I think as you sign these documents, and it's good to check occasionally on them. I know you will be filing them on the annual basis, and also whenever there is a need to update. But if something comes to your attention, always have a copy with you as a reference to check whether you have, if there's an issue that arises. You'll get your agenda. There's a listing of the matters that you are voting on or about to vote on. Always double check and cross-reference with your disclosure forms if there are any issues. And for many of you, this may not be, you don't foresee any business with which you are related to come before this commission, this board, and this will be a fairly straightforward process. Whenever you're in doubt, but this is probably, if you forget everything that I said, I think this is probably the most important slide. Whenever in doubt, always get advice, seek advice from your counsel. If you have questions. And I can tell you right now on the state level, and I emphasize this to folks from all kinds of audiences, from legislators to constitutional officers to commissioners, always get advice if you have some doubts or some questions about anything. Overwhelming majority of public officials, employees, and governmental bodies do take compliance seriously. There are very few that do stumble. In most instances, with a few minor exceptions, but in most instances, they've made a mistake, and mistakes can be avoided by asking advice if you have questions. That's all I have. I'll be happy to answer any questions you may have on anything I said or
Are there questions?
Just one question. I know that
Joe Torres.
I've signed.
Sorry, Commissioner, it's being recorded. Could you make sure your mic is on?
Commissioner Torres.
Thank you. Hear me? I've signed these forms with other, municipalities. Now, some require, notarization and some don't. Is there a need to have these forms notarized, or is it dependent upon the entity that's requesting the disclosure form?
I see that this, for example, one of those forms requires notarization. I think it's a good idea to have it notarized, just in case too. You know, there's a witness that this is truly you. You are disclosing these conflicts, or so absolutely any, for that matter, any member, your attorney here, your counsel, the agent, the MDC counsel can notarize it for you as the commissioner of the Superior Court, so you don't have to.
I also think that both Victoria and Julie are notaries and can notarize.
Yes, I can. And I did have mine notarized here, by the way. Thank you, Victoria. But I was wondering, because I know that some require notarization and some don't. I know there's a difference, you know, why there was some, you know. But for instance, that the last 12, 15 years, I've been signing these affidavits to the city of Hartford, never had to notarize anything. I was wondering, maybe those should be notarized too, I don't know. But, I was wondering, both things have been notarized for instance.
In terms of, like for example, our statements of financial interest that the state officials are required to file, they're done online, so there's no notarization requirement for those. The public officials' potential conflicts form just requires certification at the end, so no.
Thank you. Curious about that. Thank you.
Commissioner Pisano?
Thank you. Question.
Sure. You're on.
So when one recuses themselves or abstains, is it required to give the reason for such action?
Not necessarily, unless, no, I mean, you just simply recuse yourself and you walk out during the proceeding. There's no requirement.
Thank you. One other question, Mr. Chairman.
I think that also, doesn't it, Peter, doesn't it have some bearing on the rules of the body that you're doing it with? I know when I was in the Senate, you had to recuse yourself and say what the reason was for recusal, and you had to leave the chamber.
Thank you for bringing this up. That's true. It's some bodies may adopt their own internal rules that will require disclosure, and the Senate and the House also they require, if you're stepping away from a vote, and you state on the record what rule, pursuant to what rule you are abstaining from the vote.
Further questions? Commissioner Pisano, another question?
Just a point of clarification, when it comes to notarization, are we allowed to notarize our own documents? Can the MDC notarize their own documents?
No, I would, I'm sorry, is that the question?
Go ahead, yeah.
Okay.
Yeah.
Through the chair to you, you don't have to be formal, we're actually not informal, we don't have a quorum, so that's fairly.
Sure.
I can answer the question. Any notary public or attorney can notarize for you. They're notarized. It's not a conflict of interest for me or Attorney Myrtle or anyone else to notarize your signature on the document.
Even though they're our own documents that are,
Yeah,
okay.
that's fine, yeah.
Thank you, Mr. Chairman.
Further questions?
Yes.
Commissioner Taylor?
I just want to ask this question. Is there a duty to inquire? Because here it says, do you, or to your knowledge,
And in some instances, I've been involved in situations that people have attempted to qualify that language. They'll say that I'm signing this, but I just want to make sure that I'm not under an obligation to make any inquiries with regards to, for example, immediate family members, where you're required to go around and ask if you don't know, or is this just based on your knowledge at the point in time in which you're looking at it?
Well, I think at the point of submitting the form or filling out the form, to your knowledge, but I mean, there is some due diligence required if, for example, let's say your child is involved, the adult child is involved in some business activities, you know, I'm signing this form, is there any business that I should be made aware? I think there is some due diligence required, and just, yeah.
What if a member of your family, your immediate family, your children, are attorneys, and how do you deal with a disclosure or a solicitation of them relative to a conflict of interest that you would know because they have professional standards that they have to protect? They're just raising that question if you do have a lawyer, which I do in my family.
Yeah, so is this a situation where, let's say, we're talking about your child who happens to be an attorney and let's say they engage in representation of clients that may come before?
Well, that would be an easy one.
Yeah.
I'm saying, I don't know if they represent someone else that is doing business with the district, but they're not involved in that process. Is that a conflict?
Interesting question. I would say that if they themselves, if they do not derive a financial benefit,
in a law firm that's a large law firm,
yes.
I would assume that if they do work on it, I guess directly, they would assume get some kind of benefit. So you're saying if they're not getting a benefit, not part of that process of that client, that not that it's dealing with MDC, that it deals in that industry, it may, I don't know.
Sure, it's a valid point. So it all depends. If they're a salaried employee of a law firm, salaried, let's say, associate, and now there are various levels of partnerships. But if they're salaried, well, clearly they do not derive financial benefits from particular representation. It's, you know, they get their annual salary. Now, if they're an equity partner and the firm derives substantial amount of financial benefit from representing clients before certain agencies, well, the question, like, for example, on the state level, first of all, we have a prohibition for state employees from engaging in outside employment in that type of context. But for example, elected officials, they would have to be, I apologize, screened off from the law firm that employs them, or in which they are partner, equity partner. They would have to create an internal system to screen them off from obtaining any financial benefit from conflicted representation. And that's been done. We have, for example, a number of legislators right now who are employed by or equity partners at various law firms in the state. And if the law firm is, let's say, in the business of representing clients before various state agencies, they have to create kind of internal mechanism to screen them off. Their financial compensation cannot be derived from that representation of clients before regulatory state agencies. So it is complicated. It's more of a head scratcher for the law firm and also for the public official who happens to be an equity partner in the law firm. But if they're a salaried employee they receive an agreed upon salary on the annual basis, and no no bonuses are derived from representation of clients before, let's say, this body or any other governmental body, then there shouldn't be an issue there, that concept. Yes.
Just, if I may, Mr. Chairman, just to clarify maybe the question. So if I'm a member of the board and I'm an attorney and I am my law firm, I know that for a variety of reasons there may be a conflict between one of my clients as an attorney sitting on the board and the MDC. If that were to happen, my obligation would be to recuse myself here from any consideration of that matter and voting on that matter for fear that it would be deemed impartial or would be a conflict of interest because of my law firm representing someone adverse to me, right? Getting involved in that. That would be an appropriate.
Absolutely. Yes.
So, and then conversely, right, if, say, my wife worked for, and she worked for a firm, and that firm did work for the MDC, right, it was an actual contract with the MDC, right, that would be something I would list here, because again, my wife's firm is working for an entity that has business with the MDC. That firm may, at some point, become adverse to the MDC. They may take on a matter against the MDC. When that were to happen, what would my obligation be then? If I even knew it, right? If I even knew it, because she may not, for a variety of reasons, professional responsibility or other reasons, not tell me that, her firm is representing someone against the MDC. Or is it up to me to say anything that comes before the board, who they represent, who's representing them, what firms represent? How do I navigate that, I think, is the question. Other than really thinking about it, talking about it, making sure you're aware of a lot of that.
And that's a very good illustration. I think, there's some, you definitely have to have a conversation with your spouse and alert them to the fact, hey, if your firm, please let me know if your firm has a client, again, assuming, well, first of all, we assume that your spouse would not be involved in the representation, but the firm is. If to your spouse's knowledge, the firm is engaging in representation of a client, then it would be good to inform you of that. Now, do you have an obligation now to abstain from official action? It's true if it's adverse to MDC. It depends.
So I guess, I know it's hard, and I'm not meaning to put you on the spot. I mean, these are one of the things that we think about, right, in real life. If I recuse myself from any matter that relates to my wife's, again, hypothetical representation of someone against the MDC, is that enough so that they can continue to do whatever they're going to do? I'm out of it. And therefore, that can continue on with their representation adverse to the district, because I've essentially removed myself from the equation. Is that sufficient, or would she and her firm do something also? I guess, or both.
That's definitely a major step would be for you to step aside. Yes. And in terms of, the question is, will your wife derive a financial benefit from that representation?
She may very well, right? But
yeah, and so the question is this well, this is a issue of litigation. It depends. Is your wife actually the principal attorney on the matter, or can this be internally screened off and where, let's say, she informs her firm, someone else has to engage in this representation? Because again, assuming that what's the status of your spouse at the law firm? Is your wife an equity partner? Will she derive any financial benefit from that type of engagement?
And I don't know that we have a necessary answer because it's so fact specific, but I think to this situations are going to be nuanced, they're going to be unique in their facts, and that when something arises, working through this with council and others to come up with a plan to avoid the traps, I think is what's the most important thing to remember, right? Because we're not going to be able to orchestrate, what ifs on every situation. They're all going to be different.
Absolutely.
Mr. Chairman?
Yes, thank
Yeah, I think the operative word here is to your knowledge. It appears a number of times. I mean, there's no way that you can anticipate at some point, someone in your family or something, doing something outside, happens to be involved in something that you're not aware of. So, at the point, I think it's procedural now, okay? First issue is, did you have knowledge of it or didn't you have knowledge of it? If you didn't, then I think you take it to the next step, and that is that once you, once you know that you may have a potential conflict or a conflict, then at that point in time, you disclose it and you recuse yourself or abstain or whatever you have to do. But you just can't anticipate this. This is impossible. I think you have to follow the procedure. That is, that's why we have the language that we have in here, to your knowledge. Did you know about it or didn't you know about it? If you didn't know about it and the issue comes up, then you explain it, and then you take the appropriate step, which is, either to recuse yourself. That's how I see it. I mean, how else can you, deal with a situation like this other than after the fact and they take the appropriate, now, if you had knowledge of it and somehow it comes out that you do have knowledge of it, now you're in violation of the ethics provision. And then that has to be dealt with at that level. But I just don't see, how you can.
Well, from you.
That's right. You're looking at
Sure.
this, from a common sense, kind of a logical, perspective.
Absolutely. I think, you have, you are disclosing based on the knowledge you have at the time of filling out the form. Now, clearly, in response, and this is connected to Commissioner, I think, Taylor, I think you said earlier about when I said, well, you at least have to do some minimal due diligence. So, for example, your spouse is right next to your children, and you don't tell me. I don't want to know anything. That type of attitude, if that's taken, that's the flip side of not doing the minimal due diligence. It's one thing, and in most instances, yes, you may have large family, you may have folks who engage in various things, and you try to do as best as you can at the time of disclosing the information, but at the same time, avoiding disclosure or not conducting, at a minimum, some very, very basic due diligence is also problematic.
But there is a requirement for the commissioner to revise the form if in fact they find out that they have a conflict or something. That's what, we said that, we stated that it's either once a year or if there are any changes during the year that put you in that situation.
I believe it is, when it comes to your attention that there has been a change.
Right.
Is it right, John, that you then have a responsibility to go back and amend the document that you signed? So if there's a condition that does change in the course of a period after you sign this document, that all of a sudden changes, you've got an obligation to come back and to amend such and such. I guess that's what the interest is it not?
Yes, it's on the final page of the form near the signature block. It says, and right at the top, I understand I have an ongoing obligation to amend this form should any circumstances change to cause any of the statements to be inaccurate or incomplete.
And that's very appropriate. You state at the time when you fill out this form, this is your knowledge of the status of things. And if you learn later on something new, then you go back and amend. And you meet, at that point, I think you satisfy the requirements of not only the form, but also of the bylaws here, the disclosure of interest.
That would come under the best of your knowledge.
Exactly, yeah.
Further questions? Commissioner Curry.
Thank you, Mr. Chairman. I think we can all agree that voting on a negotiated contract is not a conflict. But in looking at job specs, let's say we're going to revise or even create a new one. You have a family member who, whatever the numbers are, is a member of that, or works under that job spec. So, for example, you have 100 people working under that job spec, or 50 or 10 or 5 or 2. At what level do you draw the line where you should be required to recuse yourself?
Yeah, it depends, yeah. I think the closer you get to individuals, clearly I think that would require abstention, recusal. If you're talking about general category of job specs to which everyone can apply, and there is no, members of the public can apply. There's full transparency about the process and what the committee or the board adopts. And there's no issue, even if that universe of potentially of affected persons is somewhat smaller, as long as it's fully transparent, open to the public. That's the critical thing. The transparency is critical in that process. But yeah, if you are devising job specs, let's say you are reconfiguring existing positions, and you are creating new job specs for those positions, some of which may, for example, derive a promotion. And if that universe of affected individuals is small, then probably it would be prudent to step aside, especially if we're dealing with an immediate family member.
Further questions? If not, thank you very much, Mr. Lewandowski.
Thank you for having me.
Good. Okay. Are there any further questions? If not, the appropriate motion is in order for motion adjourned. All those in favor signify by saying aye.
Aye.
Opposed?